Welcome, everyone, to the Federal Bar Association Ketam section, The Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald. I am programming chair for the Ketam section with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
Hey, let's begin with the big news. U.S. ex-rel Schutte versus SuperValu and U.S. ex-rel Proctor versus Safeway. There was an oral argument at the Supreme Court on this on the 18th of April, right?
Yeah, I heard that, definitely.
So you argued for the relators at the U.S. Supreme Court on April 18th. This was your third time before the High Court, and you had some spirited, good-natured exchanges with the justices. I looked at some of the chatter afterward. Legal journalist Mark Joseph Stern, who writes for Slate, tweeted, "It sounds strange, but the justices razzing Tejinder Singh like this is a sign of respect. They know that he can take it." So tell us, how did it feel to be in that moment?
So it's great. The moment Mark is referring to is an interesting one that I think might crystallize for some of the viewers what was going on at oral argument. Justice Kavanaugh gave me a hypothetical about how our legal rule would work in practice. And I started offering my answer. And at some point, Justice Kagan interrupted and said, well, hang on, isn't the best answer that your case is just much easier than that hypothetical? And then for a time, numerous other justices jumped in to sort of say, well, isn't this the easy case? Why do we need to get into anything harder to decide it? And at one point, Justice Sotomayor accused me of fighting the help that I was getting. And so, in the moment, I think what was going on in the argument is that there were a fair number of justices who think that the Seventh Circuit's decision likely should be reversed. We don't really know, of course, until we get the opinion, what the court actually thinks or what reasoning they'll use to get to whichever result they reach. But there was a sort of good-natured fun back and forth about, was I trying to make the case harder than it was? Or was there just a really straightforward path to reversal? And I'll say, as an advocate, you kind of feel happy when that's the tenor of the conversation, that you sort of understand that you perhaps have a tailwind there, and that at least your lead point has landed very strongly. And the question is just what's going to happen. Now, as I say, you can never really count chickens before they hatch, and I'm not doing that. The justices are extremely careful and meticulous. I'm sure they'll pay attention to all of the issues as they resolve the case. And so until the opinion's out, we don't really know what happened. But for the moment, that was an enjoyable experience.
Let's turn to our appellate court decision since our last episode here. We've got a case out of the Second Circuit, Doe 1 et al. Versus EviCore Healthcare MSI. And at first glance, this looks to be kind of a run-of-the-mill 9B dismissal case, but the complaint contains an allegation that caught our attention. Relators alleged that EviCore deployed an artificial intelligence system to approve certain requests based on flawed criteria without manual review. Artificial intelligence has been in the news lately. What's the future of AI as an area of FCA vulnerability? Let's just take for defendants first. What do you see?
So I think that there are going to be a number of cases where businesses will start using machine learning algorithms, artificial intelligence technology to conduct reviews that previously were conducted manually, and that perhaps either the law or a contract ordinarily thinks would be conducted manually. I think everybody who's been watching the AI space knows that AI is only really as good as the instructions it's given. And so AI always has the potential to lead to bad outcomes when the folks programming it don't give it the right instructions. On the other hand, it can be very useful in the sense that it can remove biases that human reviewers might have if it's programmed correctly. And so I think that there will be a range of situations where businesses will try to use AI to conduct functions that previously were done manually. I think in some instances, relators are going to say, hey, you've messed this up. Either you've programmed the thing wrong, or this is a regime that really does require a human's touch. And by using AI and perhaps not disclosing that fact, you've cheated. And I think there will be other situations where the use of AI will only make the processes better. But I think that as long as you're in a regime where it is presumed that human review would happen, the use of AI does carry with it sort of an ongoing risk that somebody would find that use objectionable, and that it may in fact be objectionable. That is, that if it's programmed the wrong way or used the wrong way, it may in fact lead to outcomes that are very different from what you would have gotten if you'd had humans doing the work.
Let's flip this and talk about AI as a tool of opportunity for relators counsel. How does that potentially play out?
Yeah, this is not just for relators, but for the government as well. I think for a while, we've been hearing about the use of data analysis to identify fraud. In the data sets that are available to relators and to the government, there are pretty substantial ones for certain government programs that can allow you to see what ordinary practice looks like. And I think a lot of data analysis has focused in the past on where are the outliers, because if somebody is, for example, billing a certain procedure at a rate that very well exceeds the normal, that might be a good place to look to see if maybe they're overbilling, for example. There are other cases where data has been used in a slightly more sophisticated way. So for example, let's say that there are 2 or 3 procedures that if you were performing them in good faith, they would be correlated. The more you do procedure A, the more you're likely to do procedure B. Maybe procedure B is a follow-up procedure to procedure A. But there are some doctor who's only doing procedure A and not procedure B. Oh, that looks weird, right? So you can use data analysis and AI to sort of narrow the universe of all of the providers and try to find ways to home in on the subset that are engaged in fraud. Data often doesn't tell the whole story. I think everybody understands that. And so further investigation is usually warranted. But I think there are a lot of situations we've seen where folks are using it. And it really is, I think, going to be becoming only more and more salient as data sets get better and more robust, and as the technology to search them and review them gets more robust.
Let's turn to our second case from the Ninth Circuit. Gharibian, XREL US versus Valley Campus Pharmacy, Inc. Here, the court takes issue with the relator's use of upon information and belief in the relator's complaint. Why?
Yeah, so there is a Rule 9b holding and a materiality holding in this case, but the thing that caught my eye as well is that certain allegations are offered only on information and belief, and the court sort of brushes them aside. Even under the Ninth Circuit's relatively permissive view of Rule 9b, it says, look, if you have these information belief allegations and you don't explain the factual basis for the belief, we're just not going to credit them. And I think that actually what often happens in these cases, if an allegation is explicitly identified in a complaint as being on information and belief, it's almost a lightning rod for skepticism or an invitation to disregard the plausibility of the allegation. And so I do think that when the court sees that, and it highlights it as part of its rationale for disliking the allegations under Rule 9b, as a practice point, I would say, using those words, it's often more trouble than it's worth. And this case is one illustration of a situation in which that's true.
Let's turn to our third case. It's from the Second Circuit. Is it Piacentile? Is that it? How's it pronounced, Tejinder?
It's Piacentile.
Piacentile. Piacentile versus U.S. Oncology. And this case dealt with the pre-2010 public disclosure bar. And you know how this case should be pronounced because it was your case.
Yes, I represent the relator in the Second Circuit in this case. And the holding of the case is that the prior disclosure of a kickback scheme by pharmaceutical manufacturers was sufficient to constitute a public disclosure of the participation of those manufacturers' customers in the scheme, even though the customers were not explicitly named. Now, in my view, this is a relatively broad view of the public disclosure bar. It's only really possible under the pre-2010 version of the public disclosure bar, which was subsequently amended, I think, to narrow it somewhat. But even under that old version, it's pretty broad. And so the court here holds that By disclosing that the manufacturers were offering the kickbacks, these public disclosures, which were civil complaints filed in what was called the average wholesale price litigation, effectively disclosed that customers were taking them. And so this customer's involvement and its activities were sufficiently disclosed that the complaint was deemed to be in part based on the disclosure, which is enough under the Second Circuit's law about the pre-amendment statute. And then the court goes on to hold on relatively fact-bound basis that the relators here were not original sources. It's an unpublished decision, and again, it's about the statute before the amendment, but it is, I think, a relatively broad application of the public disclosure bar that relators and defense counsel would be advised to take a look at.
So what are the implications of this if this kind of theory that the Second Circuit puts forward were to apply, let's say, in other circuits? What does that mean for potential relators who are going forward on cases where they have concerns about potential public disclosure?
So again, it's a pretty broad application. Prior to this, there had been some judicial decisions. There's a judicial decision in the 11th Circuit that says a disclosure that doesn't name the defendant doesn't count. And then in a split with that, there are a few other courts that have said, no, even if the defendant's not named, if they're specifically identifiable from the disclosure, let's say the disclosure refers to a class of companies that's relatively small, 1, 3, 9 companies, that would be okay because you could still figure out that this defendant was involved from the disclosure. The Second Circuit takes it quite a bit further, because all of the pharmaceutical manufacturers and all of their customers are potentially implicated here. They didn't really provide a lot of narrowing language. And so what you have in this situation is potentially a much broader application. So what I would take away from it is that relators need to be a bit more cautious and a bit stronger about developing original source allegations in situations in which they think they might have a disclosure under the pre-2010 bar. Defense counsel should like this decision. I think it's a good one for the defense side.
Our final case is UXXRL Martin versus Hathaway from the Sixth Circuit. And here the Sixth Circuit joins the Eighth Circuit in USXRL, is it Cairns, in curtailing False Claims Act liability premised on 2010 amendments to the anti-kickback statute. Specifically, the court in Hathaway holds that only submitted claims that are the direct result, the but-for cause of the kickback, are covered by the False Claims Act. What does this case add to the state of the law at the courts of appeals?
So there is an existing split, the Eighth Circuit having split with the Third, about the meaning of the amendments, the 2010 amendments to the anti-kickback statute. This case joins the Eighth Circuit on that point. It's a little bit of a sticky wicket because there are two holdings in the case. The first is that there was no remuneration and that therefore there was no kickback to begin with. And the second is this causation holding. And so this case wouldn't be a good case to take up to the Supreme Court about the question because the remuneration question clouds the causation question. That said, it does add to the conversation that's ongoing. And so here, by saying that it has to result from means but for causation, it's made it more tricky to use the 2010 amendment to establish a per se kickback, per se false claim, I should say, when you have a kickback. That said, there has always been another way to get from anti-kickback violations to False Claims Act liability, and that is just the express or implied certification theory that has always been around even before those 2010 amendments. That theory has some extra elements. You have to show that there actually is a certification that's relevant. You have to show materiality. And so you can't take the shortcut that Congress created in 2010, but it avoids this causation problem, at least for purposes of establishing liability.
And so what I'm hearing from you is that relators potentially could opt into one theory or the other at summary judgment, the pleading standard at summary judgment and at trial.
Yeah, and there's actually no reason to choose because they're not mutually exclusive. If you think you can make both arguments, I would do so. I would say you violated the anti-kickback statute And we think those violations caused these claims. And we also think, even if they didn't cause these claims, they were material to the decision to pay claims. And I would make both arguments if you think both are available on the facts of your case.
Tejinder, thank you. And thank you for joining us for this edition of the Federal Bar Association's Key Tam Sections, The Rounds, FCA News with Tejinder Singh. We look forward to seeing you next time.